Hello and welcome to Olmsted in 5 Minutes, a series of 5-minute podcasts about the Olmsted decision and Olmsted advocacy created for the olmstedrights.org website by the Atlanta Legal Aid Society. In this series of podcasts, to start out with, we've been talking about the Olmsted decision and what it is. In our last podcast, we talked about how the U.S. Supreme Court gave 3 factors that should be considered in determining when a person with a disability has the right to receive supports and services in the community rather than in an institution. In this podcast, we're going to talk about the 3rd factor because that's the most important factor of the 3 factors. The first, again, is that treatment professionals say that the person can live in the community. 2, the person does not object to living in the community. And the 3rd is that the state can reasonably provide the supports and services in the community without fundamentally altering the way in which it provides supports and services to all other people with disabilities. Now, this 3rd factor, the U.S. Supreme Court spent a little more time discussing. In a plurality part of the decision, the United States Supreme Court looked at the balance between reasonable accommodation and fundamental alteration. And it specifically gave an example of when a state might be able to raise what it called a fundamental alteration defense. And a state could raise a fundamental alteration defense if it had an effective working plan with reasonably paced moving waiting lists to transition people with disabilities into the community. One of the realities the U.S. Supreme Court seemed to be recognizing is that states would not be able to, just at the snap of a finger, change from providing supports and services in institutions, such as nursing homes, psychiatric hospitals, institutions for people with developmental disabilities, would not be able at a snap of a finger change from those institutions to providing supports and services in the community. Oftentimes, the supports and services simply did not exist with the amount and scope necessary in the community. So what the court said is that one way a state could, and really the way a state could argue that it is in compliance with Olmsted is if it had a plan, but a plan that was effective and, most importantly, that was working, that it was actually carrying out to transition people with disabilities from institutions into the community, and that there was a reasonably paced moving waiting list. In other words, that people were moving through from the institutions into the community. Now, one of the realities is that it's been 15 years since the Olmsted decision. So one question that advocates should and often must ask is whether or not those plans should have already been carried out, or certainly that how far along they should be, given the fact that the U.S. Supreme Court issued the Olmsted decision in 1999. Regardless, many of the states have interpreted the U.S. Supreme Court's decision about effective working plans to create what they call Olmsted plans. And these Olmsted plans are supposed to be plans that enable people with disabilities to be provided services in the community. The reality is that it is a rare state, if any state, that has really created what the Supreme Court said that it should create in terms of an Olmsted plan, that it be effective, working with reasonably paced moving waiting lists. Often a state may raise a fundamental alteration defense in litigation around Olmsted, but it may not be effective because the state may really not have an effective working plan with reasonably paced moving waiting lists, and so it really does not have an Olmsted plan. But that's going to be the issue that is often going to be litigated in an Olmsted case, is whether or not such a plan exists. Thank you. We hope you've enjoyed the 3rd of our 5 Minutes of Olmsted podcasts. We hope you'll join us next time when we discuss what happened after the Olmsted decision.